the Radnor Township Zoning Hearing Board meeting for April 17th. Will everybody please join us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first matter for this evening is appeal number 3157. The applicant is 411 West Wayne, LLC. Property located at 411 West Wayne Avenue. Requests an extension of time for obtaining a permit under Section 280-144 of the Code until November 5, 2025.
Thank you, Mr. Chairman. Good evening, Fred Fromhold. You're seeing me more often in connection with requests for an extension of your zoning order than you did when we were before you to obtain the approval. This is another request on behalf of our client. We are hopeful this is our last one. We had previous requests, as I had explained in our letter, because we needed land development approval. We had UCC approval that we had obtained from the Commonwealth of Pennsylvania, and we finally obtained the Darby Creek Joint Authority approval just before we filed this request. I'm happy to say that the last approval that we needed, short of a building permit application and approval, was received April 9th. The Design Review Committee approved the design, so the architect and the owner are now confident that the building permit application can be submitted, that the plans have met the design review. So we are requesting still another extension that would permit time to obtain the building permit because the zoning approval, as stated in your original order, required that a building permit be obtained within the required period of time. So we would respectfully request that you approve this request for an extension. Hopefully it is our final one.
I just have one quick question,
Sure.
Mr. Fromhold. So I see just in the letter that was drafted,
Yes.
just stating that basically you're going out for a building permit just as the client's architectural plans are kind of modified or adjusted. Is that correct?
They have been, to my understanding, the Design Review Committee of the Township approved the design on the 9th of this month. So
Okay.
that is freshly approved.
Okay.
Yes.
So, and that didn't impact the relief that was granted previously?
No, it did not. And I should note that this application, when originally submitted, had been the subject of some back and forth with people from the community, and when ultimately it was presented to you for approval, it was uncontested, as noted in the board's decision.
Thank you. That was my only question.
Good.
Appreciate it.
Good. Thank you.
Any other comments or questions? Is there general agreement to by the board to move?
John, make sure you use your mic.
Thank you. Is it correct that all the members of the board agreed to the extension? Do we need a formal motion?
Yeah.
Okay. All right.
Thank you very much. Yep.
The next item on the agenda, excuse me, is appeal number 3206. It first came before the board on March 20th and was continued to this meeting. It is appeal number 3206. The applicant, John Fitzgerald and Piera Raphael. Property located at 514 Midland Circle and zoned R3 residential. Applicant seeks relief from Section 280-25.E of the code to encroach into the rear yard setback, section 280-25 -25F, to increase the impervious coverage from 40.3% to 44.3%, and section 280-27-C, to allow retaining wall greater than 3 feet in height to be located 2 feet off the side yard setback where 10 feet is required. As I noted before, this matter was continued from the March 20th, 25 meeting.
Thank you, Mr. Chairman. David Skaggs for the applicants. So if you will recall, when we were here last time, one of the issues that the board seemed to be concerned about was the request for impervious surface, and the board graciously suggested some ideas that we could address those. So we went back to the drawing board and redrew the plan a bit, removing some impervious surface from the driveway itself, as suggested by the board, and I'm happy to report that we were able to remove enough of the impervious surface so that we actually decreased what's existing and no longer require a variance for the increased impervious surface. And so if I could, I just handed up what we would probably mark as applicant's Exhibit 7. I believe that's where we were in the list from last time.
7 would be what was just handed up, I believe.
Yes, so that would be our revised plan. That would be marked as Exhibit 7.
Exhibit 7, thank you.
Yes. And while I believe we also, although it's not part of our relief, we did move the retaining wall in the rear of the property a couple feet away from the boundary line as well.
Okay, so is that the lap pool that we see on the plan,
Yeah,
Exhibit
you see
7?
There's a pool here. We didn't really need relief against the rear boundary line at all, but we did move this retaining wall a couple feet closer to the pool, away from that rear boundary line.
Okay, so just so I understand, and the board understands, the retaining wall that appears near along side of or adjacent to the lap pool is not a subject of zoning relief?
That is correct. The retaining wall that we had sought relief for is on the side here, and it's only for the portion that exceeds 3 feet, as the township considers anything over 3 feet an accessory structure. So I believe it exceeds it for about a foot, for about a 15-foot length.
And the new plan, Exhibit 7, that you handed up this evening, and is admitted, shows the reduction in impervious surface?
It does. If you look in the zoning summary, the maximum impervious surface is listed as 35. The existing is 40.3. We had originally sought to increase it to 44.3. We're actually able to reduce it to 39.8.
So you don't need relief then for impervious coverage?
We do not. We're withdrawing the request for relief for impervious coverage, and we're actually able to reduce the existing impervious coverage.
Maybe we can go the other way.
What's that?
What relief or what are we?
Yes.
The remaining relief that we're seeking is for the retaining wall on the northern side for a stretch of about 15 feet to exceed the 3-foot maximum, to go up to about 4 feet. And then the rear of the home, an encroachment into the 35-foot setback, a distance from 1.8 feet to 2.9 feet for about half the length of the home where the garage is.
It's already non-conforming.
It's already non-conforming, yes. It's already not, oh, actually, is it already non-conforming? No? No, I don't think it is, no.
So a little bit louder, I didn't hear that.
No, the solicitor
Speak
asked
more
if
into the microphone, okay?
the solicitor asked if the garage was already non-conforming, and I confirmed with the engineer it's not.
So is it clear on the record what is left of your appeal that we are
Yes. if you-
considering?
If you'd like to, I'd restate it. There were 3 requests. The first would be for the encroachment into the side yard setback on the northern side of the property so that we could have the retaining wall exceed the 3-foot maximum by about a foot for a length of 15 feet. The second one was the encroachment into the rear yard, anywhere between 1.8 and 2.9 feet. And then the third was the request to increase the impervious surface, which was the pre-existing nonconformity. We no longer require that, and we will withdraw that request.
Okay.
So I understand the impervious issue, and my recollection was it had to do with the extension of the driveway.
Exactly.
Okay, so I did not pull out the old plan, but the driveway as it sits on the new plan.
You want to see what we did?
Yeah, if you could show the difference, because, yeah, I'm curious if you reduced the size or if it's just,
What we did was, we took the board's advice and we carved out a 3-foot section in the middle of the driveway, extending all the way back to about halfway through the house. And we also are taking out some of the driveway that abutted the home. And with doing that, we got under the existing impervious.
You said you took out some of the driveway in front of the home?
Abutting the home, on the northern side of the home, you can see right along here, some of the driveways removed compared to the existing footprint.
Okay.
but the dimensions as they were presented are the same.
They are.
Okay.
David.
The lower part of this A7, existing, I'm sorry. Yep, can you explain what the pink sections are on that bottom?
The pink sections are the impervious surface that we're removing. If you recall, there was a large, I don't know if it's slate-type patio in the front. We agreed to withdraw that. And then you can see part of the, well, I guess part of it is the garage. That's not the, part of it is the asphalt drive, but it's going to be replaced with a garage.
Okay, and then how about to the rear of the property? There was impervious coverage back there?
Yeah, that's a part of a stone retaining wall that's currently there in the rear of the yard, and it's going to be replaced with, in the similar position with the retaining wall you see in the proposed improvements.
Okay, but drawn in towards the, sorry, I'm saying it the opposite as I want to. Closer to the home.
Yes, yes.
And that rear property line, though, is not in front of us tonight?
It is not,
Okay, thank you.
other than the encroachment into the rear yard by a foot to 1.8.
Of the garage.
Of the
I understand
garage.
that, yes.
Yeah, but nothing near the rear property line.
Yeah, okay, thank you.
Question for our counsel. The verbal modification, well, actually, it's not a verbal, it is a verbal modification that the relief being sought is different because of changes adopted, but there as reflected on what is now Exhibit 7. Is that all correct? And that's sufficient? We don't have to do more?
No, that's, I mean, they're seeking less than what they were asking for before, so they've
Okay.
reduced the amount of any relief they were requesting. So as long as they're doing that.
I'm sorry, I'm just not close enough, my apologies. So no, there's nothing further you need from the applicant. They've satisfied with all the requirements they need to reduce the requested relief.
Okay. Any other questions? Any questions from the board? Now, next would be public comment, but we've been made aware that there is some residents that want to be, have asked for party status. Are you aware of that, council?
I was made aware of that this week.
Okay. And I understand that the folks that are seeking party status is Deborah Morady Whistle and Paul Whistle. Is that correct? Okay. One final piece of housekeeping. You've moved your new drawing into,
I heard you say it was omitted, but if I haven't, please, I move to
okay,
admit
so it is
Exhibit 7.
admitted. Any further comment from the applicant?
No, but if you're going to entertain any testimony from any other parties, I would like the opportunity to respond. I don't know if we're there or if this is just public comment.
I think we'll move directly from your presentation to the folks who have asked for party status.
Okay, then I'll
Okay, so
reserve
you can
the right to
reserve a right
cross.
to return and ask them questions and make other comments as you see fit.
Thank you.
But I'm not, just in case, could you also move in your exhibits from the last hearing as well?
Oh.
I don't know if that motion was made, so let's just to
Yeah,
I
make
believe it
sure.
was, but if it
everything.
hasn't been, I'd
Yeah.
request that all my exhibits be moved into evidence.
Granted.
Thank you.
Okay, so would you please come forward, Ms. Whistle and Mr. Whistle? Russell?
Hi.
Okay, now, please, make sure you speak up when you're there. You have to be sworn in again, I believe. No? Okay.
I'm Paul Whistle, 214 St. David's Court. My wife, Deborah. I live at 214. I live at 214 St.
Do we
David's
have the
Court.
handset?
I'm also I have ownership at St. David's.
Do you want it?
Sure. I also have ownership of St. David's Park, so I can speak somewhat about that. And there may be a trustee in the audience from St. David's Park.
Let me see if I'm smart enough to do this. Ah, there you go.
I haven't had the opportunity to see the new drawing until it was flashed up, so my presentation will be on the documents I've had available. Here's our concern, and the specific concerns and what I'd like you to consider is, does the proposal request for 3 variances to extend the setback, to extend into the setback, remove the existing soil, wood, and stone permeable retaining wall, and build a new, long, all-stone retaining wall exceed de minimis?
Excuse me 1 second. I know you requested party status. I don't know that we've actually approved party
No,
status.
it's
So
we sort of
procedurally,
launched into things before we had a
yeah,
chance to do
you're a
that.
bit out ahead of the gate. So
Yes.
just, yeah, we just have some housekeeping.
Okay, so let's just put a couple of things on the record. You're obviously, I shouldn't say obviously, but you are residents of Radnor Township.
Yes, we both
And
are.
you live, your property, where you live is adjacent to the property
Yes,
of
we
the
are.
applicant, is that right?
Yes.
Okay. And under those circumstances, you can ask for party status. Do you know what that means?
Not entirely. I understand it means I can talk today, but I don't understand the legal ramifications of that.
Okay. It means that you can present some testimony, although it has to conform with, while we don't have formal rules of evidence, it does have to pertain to the applicant's zoning request and be specific to that. And if you have someone here that's going to present some form of expert testimony, that the person has to be qualified as an expert.
Understood, thank you.
Do you know how to go about that?
I don't,
Procedure.
but there's no one to talk about this other than my wife and I tonight. We had an expert a month ago, but those different circumstances.
So I think at this point, there's enough on the record that we can determine whether or not you should be granted party status. Is there any objection to granting party status to Deborah Mulready Weasel and Paul Weasel?
No, they're adjoining property.
Okay. I see no objection, so you have party status now.
Thank you, Mr. Lord. So we had 3 concerns and requests for you to consider. One is the proposal request for 3 variances for the one new wall that extends to the setback, removes the existing soil, wood, and stone permeable retaining wall, and builds it longer than that seems to exceed de minimis. It does not seem to address a hardship, and we request that you deny that retaining wall. Also, have all the increased impervious surfaces resulting from the new pool been accounted for? And we request that you deny it until all the impervious surfaces that would be part of the new pool have been identified and put into the calculation. And the last one is the applicant says that it's not going to be detrimental to public welfare, and we disagree that some of their plans would be detrimental to public welfare, and we have an example where that has already occurred from their property.
What are the plans specifically that you state would be detrimental to public welfare? And please identify specifically the welfare of the public that you're talking about.
That would be my 5th thing. Do you want me to jump ahead? No. Okay. This is the plan that was proposed, and it seems to be about the same. And this is the lap pool that's new, and this is the new retaining wall that was initially presented 4 weeks ago as being 2 feet from our property line, and there is a 10-foot setback. We'd like that to be preserved. Here I've outlined the things. One is, the first point is they want to encroach 8 feet into the 10-foot side yard to build a retaining wall that's 1 foot longer than it should be, and it will add to the impervious surfaces currently in there. There is an existing retaining wall that's been functioning for a long time. I don't. This is the retaining wall. I don't think the group has seen it at this point, but it looks like been there a long time. It's mostly soil, so it's permeable, and it's quite large, but it's functional. I don't think there's anything wrong with it that requires a second stone retaining wall to be built and have this one, because it's working. So why would it be de minimis to take it? Here's another
Excuse
picture.
me 1 second. So
Yeah.
the record's going to be crazy because you're looking at photographs that aren't identified, but we can fix that. I'm curious, the photograph that you just had before this one,
Yeah.
and give me 1 second, let's put a page count to it.
Just for the record, this is, the parties testifying now is referring, I think, to documents that are in the neighbors' concern on Appeal 3206 Zoning Board meeting. Deborah and Paul Whistle, 214 St. David's Court, St. David's. Is that correct? You're referring to documents that you put together in this
Yes.
brochure?
So this picture is in that document.
Yeah, page 9 of that document.
So when I
is
took,
this, let me ask my question,
oh,
please.
sorry.
That photograph is showing us what, your neighbor's property or your property?
This is the neighbor's property. On the other side of this wooden wall is our property.
Understood, okay. And
So that's page 9.
I was
I
standing.
forgot what I was going to ask you.
I was standing here on my property when I took the picture.
Oh, this is the rear property line, though, correct?
Yes,
This
side yard.
retaining wall is not in front of us tonight. It's not at issue.
No, this retaining wall here is the replacement.
No.
No,
No, the one at the top of the page
by the driveway.
by the driveway. is what's at issue in front of us, not to the rear of your property line.
That wasn't discussed at the last meeting.
It was
It
discussed.
was clarified. I understood it that way. But, so if you could move on from, keep it relevant to what's in front of us tonight,
If
please.
I may, is he testifying? Because I don't know that he was sworn in.
He was under oath from the last meeting.
Correct.
Okay.
Thank you.
And just to reaffirm that you do understand that you're sworn in to give truthful testimony at the last meeting, and that oath continues into this meeting. You understand that, is that
I
right?
do understand that,
Okay.
yes.
All right, go ahead.
So I don't understand why they have to build a second stone wall, that it's not de minimis to say, I need to build a stone wall here.
Sir, that's not in front of us tonight.
I didn't have the opportunity to present last time, and my expert was not allowed to
See,
testify.
the last time, this wasn't before us. That's maybe a difficult thing to get your head around, but the fact of the matter is that the board considers those things where zoning relief is necessary for the property owner to achieve what they want to achieve on their property. Now, in this instance, they did not need any zoning relief regarding this wall that you see back here, okay? Or the lap.
I can't
wall.
quite see.
That's here, and that's why we're not, even though you have a party status, the party status is to be able to comment on those things that are actually pending before the board. This is not pending before the board, so we're not, that's why we're telling you that we don't really need to hear what you have to say on that topic, because it's not something under consideration.
We're saying this is a safety
Under
issue.
consideration by the zoning hearing board tonight.
We're saying this is a safety issue.
It's
and we've already-
irrelevant.
Then it's
It's not relevant to us tonight.
Yes.
I'm trying to be respectful, but you're not being respectful to us.
We've tried.
Did you?
We
Did you
have.
read your letter? Did you intentionally threaten this board? Or
No,
was that
not at
by
all.
mistake?
Not at all.
Not at all?
We've met with Kevin. We've tried to follow the rules.
And
to
then you
be fair.
decided to threaten this board?
Excuse me?
If I can
Read your
move,
letter, ma'am.
if I can move on to, the next point is that they said the impervious coverage will increase by 4%, and that math is wrong. So when you made the decision, you were looking at the incorrect math. That's an error. The legally non-compliant is 15% above code. These are their numbers, not mine.
But you were sitting here in the audience when the presentation was made by the applicant's counsel. And he said and made the point several times that they have reduced the amount of impervious to the extent that they no longer need relief from the zoning code. They do not need a variance. So that issue is off the books, off the board, and not within our consideration. And the council has said several times, and I'm sure that he'll reaffirm that when he has the opportunity, in light of your comments, that that's not before the board. They went back to the drawing board, so to speak, and redrafted the drawing. There was an example of it up there. It's now in the record as Exhibit 7. I don't have an extra copy, but you'll recall that it was stated that that relief is no longer necessary because they have reduced the amount of impervious coverage below that, which is the minimum required by the zoning code. And I wrote the number down, but I don't.
Well,
It's like 39.2% or something. So they don't need relief from that aspect of their proposed plans.
their math was wrong before, and I haven't had a chance to look at their new plan to see if their math is any better. But when they said it's a 4% increase over currently legally non-compliant, that's not correct. By their own numbers, they're asking for 14.
Well, it's irrelevant, sir, because they don't need that relief. And you can pick away at their math, but that has been withdrawn because their new plans that they put together as a result of the last hearing is remove that issue from consideration by the zoning hearing board. So there's really nothing to talk about. It's
I'd like
not,
to-
it's no
I'd like
longer
to-
relevant.
I would like to have the goodness of time to see if their calculation of what they changed still doesn't show that they're around 30% above code.
Okay, well, you'll have to do that on your own, not here tonight.
Last time, and this gets to the point about public welfare, our arborist was here 4 weeks ago and was not allowed to testify because he didn't live in Radnor, and he still doesn't live in Radnor. What he was able to show us by his own expertise was that the
Object. The arborist isn't here. I can't cross-examine him.
We'll have to sustain that objection. It was explained before that you should have applied for party status at that time. You did not, and we can't, you know, the arborist is, first off, he has to be qualified as an expert. Okay, and you know, we would lead you through that if you don't know how to do it. And the standard for expert testimony is pretty low. I mean, you just have to have some specialized knowledge. But in whatever the area is under consideration. But counsel's correct. If you're going to read from the report, we can't permit that because it's a hearsay document. That means that there's nobody here in the room who actually is the author of this thing and can explain it and also answer questions that were that counsel would want to put to the arborist, including questions that this board would want to put to the arborist to determine the reasonableness and the accuracy and what weight should be given to any of the opinions that are expressed in this. And the opinions that are being expressed by the expert are purely those of the expert. And you can't just read them into the record.
If you would want to delay, I would bring the expert here. Last time I understood he was not allowed to.
Now, don't use the terms "not allowed." The document was not presented properly. You were not parties at that time. A little bit of homework, obviously, has apparently been done by you and your wife, and now you're here as a party, but you didn't bring the arborist. I fully expected you would bring the arborist and thought that was one of the reasons why you wanted to become a party to this process.
I showed this picture with the arborist here 4 weeks ago.
You cannot testify for the arborist. That's end, full stop.
Can I ask you a question on that? I understand why you want to talk about, you know, what the arborist's opinion was, or at the very least what your understanding of the arborist's concerns are. But I think I'd like to understand the relevance, if you could answer for me, what relevance does that have to the relief of a 15-foot section of the retaining wall on the northern side of the property and the 2-foot, give or take, encroachment to the rear?
The digging of the roots of 70-foot trees will lead to instability of the tree at some point, sooner or later. There's been a tree that's already fallen from the applicant's property in 2011. It fell across my property, hit the garage, put a hole in my neighbor's roof. This is what my neighbor, who's too ill to show, but he was saying it's a 3-by-2-foot hole in his roof because one of the trees fell. That's not hearsay because it's my property, and I saw it. So
Yeah,
I saw
Pennsylvania law, the tree falls where it falls.
it falls where it falls, but
Right.
this will lead to further instability.
But again, I understand your concern is digging around this root structure, but my question is, what in the application is implicated by that?
The application is where he said there's no detriment to public welfare. And in fact, to make these 70-foot trees that can fall on my house, his house, St. David's Park property, makes it a public welfare. Their statement, not mine.
Are you worried that when they expand the garage, they're going to impact the roots of the trees on your property?
No. We are
Are
only
you
concerned.
worried that a 15-foot section of a retaining wall that's 4 feet, I think I'm right, Counsel, 4 feet, will impact these trees on your property?
Yes, because to
How will
build
the retaining wall on the north side, what side are your property adjacent to the applicants?
the
East.
side yard is their southern side, and it's that retaining wall that on this diagram is 2 feet from our property line is the only thing that we are concerned about because it encroaches on the 10-foot setback.
Can we clarify, Counsel, the retaining wall is to the north side of the applicant's property, is that correct?
Yeah, if we could put the plan back up so everybody could see it.
Please. Is to the, your property is to the east of the applicant's property?
Actually, both. We own property at St. David's Park
But
as well.
we are south.
But
You're
our
s-
house where we live is adjacent, is behind them.
Behind them, right. So the retaining wall that your husband's concerned about,
Is this one right here.
yeah, that one is not in front of us. The only questions and the only testimony that's relevant is to the retaining wall on the, I don't know, counsel said it was on the north side, on the driveway side. North by northeast side of the property, the applicant's property, and the expansion of a garage. That's what's relevant, that's what's in front of us tonight. If you have testimony or comments with respect to those two pieces, we are here to listen to you. But we're not going to let you talk about retaining walls that are not in front of us.
Well, I'd have to say I'm disappointed that I didn't have a chance to present last time. I was just given party status a few minutes ago. There's a retaining wall that's going to cut into the roots, and the town that I pay taxes to won't let me talk about that. I've tried to reach out to the applicants through our Ward 3 council member, and I haven't had any possible interaction. So I'd have to say I'm disappointed that these things I'm finding. Also, that the impervious area is not adequately described. There's areas that they will need to have increased their impervious area that is not identified there. And so that makes this plan insufficient. This is the proposed pool. It doesn't show a pump. It doesn't show a filter. Filters and pumps need flat areas. They need, so the drawing
Again, once
is
again, the
wrong.
pool is not before the board. They're not seeking relief for the pool.
But
So
the-
your comments are really not helpful to the board and not relevant to what's before us. I mean, you're granted party status to comment on what the applicant is, on the variances that the applicant is seeking. Honestly, it's not just to talk about whatever you feel like talking about, because a lot of it is irrelevant and not pertinent to why we're here tonight.
There is,
That's been explained numerous times through the course of the evening.
but they will have to increase the impervious area to accommodate what keeps the pool clean, and that's not on the map. They will have to. There has to be, and that's not identified. They will have to have flat, impervious area to hold the pump, to hold a filter, and because it's surrounded by trees, it's a cold
So-
Do you have intimate knowledge of the placement where they're going to put the pump? Because I don't think it's appropriate for you to comment on something you don't know.
It's not marked. How could we have knowledge?
I actually think it's a fair question, with respect. Is the pool that's shown on the plan in the calculation for the impervious coverage?
I can recall our engineer, but
Please.
first I'd make a note that he's giving expert testimony. You know, I think an expert would have to testify what is needed from
Well, we'll
That's
give
fine.
it the weight that
Yeah.
it deserves, and cognizant of those issues, that there are conclusory allegations and statements being made with little or no support for them. And I think we're allowing a lot of leeway because the party status folks are not professional, either by engineering standards or attorney or evidentiary understanding. But I don't know that the pool is typically considered to be an impervious surface.
Yes, it is.
But it's shown on the map, or the plan, I should say, and it is not a subject for which the applicant is seeking relief. So consequently, it's not relevant, your comments are not relevant for our consideration here. Since
John?
we only have the opportunity to rule and pass on those appeals for the specific items that we've been discussing.
John, I'm sorry. I would like to hear if the pool is in the calculations of impervious coverage.
And why is there an absence of the additional impervious flat area that will hold 2 pumps, a filter, and very likely a heater? That's not on the plan.
And that may be a problem for them when they come back to actually build the pool.
That's public welfare if you have a big pool of
Okay.
water.
Sir, I'm indulging you. I've
Yeah,
asked the
please, no
engineer to answer a
lectures.
question that I think you had a very good question, and you're just speaking right over it.
All right.
We don't need to hear from the engineer.
All right. We're happy to provide that information if you'd like.
Okay, well, I think
Please.
if you're going to do that, has the engineer been identified?
He testified last time.
Okay, and you're,
First name is Michael. Last name is Rokosny. It's Rokosny.
and you were sworn the last time?
Correct.
Okay, go ahead. Keep your voice up, please.
Sorry, if I could just get the whole plan shown on the screen here. Okay, I'll just run through our impervious calculations here. So the bottom plan is our existing conditions and demolition plan. Everything shown in red is the areas that we're proposing to remove. The proposed plan is showing the proposed improvements. The dark brown is the garage addition. The slightly darker brown is the proposed retaining walls. The dark gray area is the driveway extension. The blue area is the water surface, and the tan area going around that is the coping for the pool. In the Radnor Township ordinance, the water surface is considered pervious, so the water surface itself is not considered part of the impervious calculation. The coping for the pool is included in our impervious coverage summary.
Thank you.
And again, we're not seeking relief for the impervious coverage, and we're still in the design phases. This is a very early process, so if we were to include a small area for the pool equipment, we'd have to remove a proportional area, so we would never be seeking relief for the impervious coverage.
Okay. And
And we're still under the impervious coverage allowable. So we have an existing nonconformity of 40.3%, and our proposed plan brings it down to 39.6%. So we're not they're seeking relief for impervious coverage.
I know what I was just thinking. I'm sorry. It dawned on me. If I may, you heard Dr. Whistle mention a mistake in the math. Are you aware of a mistake in the math from the previous plan?
Not from the previous plan. I mean, I have reviewed and checked our numbers, and it's
Okay.
going to go
And-
through the whole review process through the township.
All right. And do you, the charts and the math and the calculations that are contained on Exhibit A7, are they accurate?
Sorry, Exhibit A7 is the revised plan?
The revised plan.
Correct.
Are those calculations accurate?
Yes.
So this is wrong, that if you have a 35% code, the impervious addition is the legally non-compliant is not about 50% increased. You said 40.
From 40.4 to
Will you hand
44.4
him the
is,
microphone?
what was that?
As he's talking, he needs the microphone.
That's percentage points, not percentage. Percentage points is, yes, 4, but 4 percentage points of that is but it's 10%, you know that.
Yes, but again, we're not seeking relief from that section anymore. We've revised our plan.
Got it, okay. And again, just for clarity for the record, the calculations that are contained in the charts on Exhibit A7, which is the revised plan, are those accurate?
Yes.
Okay.
Mr. Weissman, Mr. Kachanski was good enough to bring to my attention that, as you typically do as a board, you make any, I'm sorry, Norma, I'm so sorry. As the board typically does, you make any approvals or your decisions conditioned on the exact conditions of the plans as presented. So those percentages that they're showing you for the impervious would be the maximum they could come back with if they do some changes for the pool for purposes of pumps or anything else.
I'm sorry, can you explain that a little bit better?
What they've presented as their Exhibit 7
Yep.
is the maximum they would able to get approval for a building permit or for anything else they want to do on this project.
So this number is fixed?
Correct, tonight. Assuming the board approves it, obviously, they still have to make a decision.
I understand.
But it would be, this board typically, I don't want to speak for my board, but they typically will make any approval conditioned upon the specs and plans presented at the hearing.
Thank you.
And to reiterate, we're decreasing the impervious area on site.
I think we're done, babe.
Anything further?
Thank you for your time.
Quick response? Very quick. The comment was made that the Whistles had sought assistance from a council person. My client did meet with Councilperson Agnew, and as a result of that meeting, moved the rear retaining wall further away from the rear property line. So I think everything else was covered.
Just to clarify again on that rear retaining wall, we're not seeking any relief for this wall. This is off of the setback and below 3 feet, so it's not considered an accessory structure.
All right, very good, thank you.
Mr. Chairman, your mic, please.
All right, very good, thank you. Any public comment? Any board discussion? Can I have a motion, please?
I'll do it. So I make a motion that the application for variance from section 280-25.E to allow the principal building to encroach up to 2.9 feet into the rear yard setback of 35 feet. Should I do these as separate? I'm just going to do it all as one. And that we approve that request, and that we likewise approve the request for relief from section 280-27.C to allow 15.5 linear feet of a retaining wall greater than 3 feet in height to be located 2 feet off the side yard setback where 10 feet is required. And that's all in accord with the plans and testimony as presented to the board.
A second?
Oh, yeah, I'll second it.
Okay. Any discussion?
It seems like a lot of effort was put into addressing some of the concerns the board had before. It seems like they really focused on issues that we had, and I don't think you can ask much more from a person trying to present information to the board. You know, we committed to the community, but we also have to respect individuals and what they do on their property. So I think that's an important part of this.
Okay, thank you.
And it's not that we're insensitive to the concerns that were brought before us, but we are limited by our codes and the municipal planning code. We can't create law.
Right, we have to consider only those items that are actually before us that require relief from the zoning code. And that's why some comments, while they certainly may be of concern and pertinent to the individuals making those comments, they're not something that the board can simply consider, because we are bound by the municipality's planning code and limits us to the things that we can discuss and what we can do up here. So, any further comment by the board? Okay, we have a motion. Can I have and it's been seconded, so can we have a vote? In favor?
I'm in favor.
Aye.
Aye.
And I'm in favor, so it passes.
Thank you for your time.
Oh, wait a second. Let me just put this to the board. Oh, the second in line, right, okay. All right, the next item on the agenda is appeal number 3207. The applicant, Spicy Bricks LLC, property located at 912 Conestoga Road, zoned GHCR. The applicant is requesting a variance from section 280-49.8A14 of the code to allow for the construction of installation of a prefabricated pergola roof structure over a paved patio within the front yard setback.
Mr. Lord, good to see you.
Good to see you.
David Falcone here on behalf of the applicant. As was just described, we are here seeking relief to install a prefab pergola within the front yard within the GHCR district along Conestoga Road. This pertains to outdoor dining for the restaurant Exit 13, which is located there in Garrett Hill. The relief we're seeking tonight is curious in a couple of ways based upon the outdoor dining code of the township. Outdoor dining in this particular district is required to be within the front yard when you abut a neighboring residential property, which Exit 13 does. So the options for outdoor dining for this restaurant in Garrett Hill are in the front yard, and it is permitted by the code in the front yard. It is required to be placed on a paved surface, and it is required to be covered for health and safety reasons by the township. As you read through the code, it is requiring that the items that are installed or constructed in that front yard be attached to the ground, and that those attachments simply be outside of the right-of-way, but be within the front yard. So as we navigated how to accomplish these things, there would be no way for an outdoor dining covered pergola to be installed without relief under the code. With that in mind, Luciano, who is the owner and operator of Exit 13, went through various iterations of ways to separate that outdoor dining, again, which is encouraged by the code, to separate it from pedestrian areas, from sidewalks, to construct either fences or other barriers to create a private dining area inside of that front yard. So when considering the options, Luciano came back with again, prefab, open-sided pergola cover that would allow for clear visibility looking through the pergola. Only thing there, the things that would be most impactful to sightline would be the patrons themselves and not the constructed pergola. Looked for opportunity to meet the required sidewalk setback from the restaurant while also creating the deepest possible setback within the front yard setback. So what you'll hear tonight, and just very brief testimony from Luciano, because again, this is not with respect to use of or outdoor dining itself. This is respect to placing of the pergola within the front yard. You'll hear that the pergola itself is going to be set back approximately 15 feet from the edge of that drive aisle on Conestoga Road. It'll be set back 8 feet from the outside edge of the existing sidewalk. And then it'll be set back approximately 2 feet from the edge of the right-of-way. So most of the improvements in fact, all of the improvements on the ground exist today. The patio exists, there are bollards that exist, sidewalks exist. The only thing we're seeking to do is place the pergola on the existing patio and then attach it per township instruction to the ground so that it's stable pursuant to the code. I've pre-marked a couple of exhibits for the board. A1 through A5, I've handed them out to y'all. A1 is your application, the zoning hearing board application. A2 is a copy of the deed. A3 is an aerial photograph of the property. A5 are some photographs of the existing conditions. I'm sorry, A4 is photographs of the subject property, A5 being a plan sheet with a rendering showing the intended pergola for the front yard. The pergola itself will be approximately 13.5 feet deep, 34.75 feet wide, and about 8 feet high. It'll be open on all sides, again, and there'll be no additional fencing enclosure that'll be installed as part of the pergola. So if there are no questions for me.
I have a question.
Sure.
I'm sorry.
No, great.
The plan A5, I know I'm getting way ahead of you.
Sure.
Are there any indications on this plan of what the measurements are that you need relief from?
There are not. I will tell you it's a 2-foot. The pergola itself will be 2 feet outside of the right-of-way. So we'll need relief. The setback itself is 22 feet. We'll need 20 feet, I believe, of relief.
That's what I'm looking for.
Yep. So again, I think there is a question as to whether or not a prefab pergola itself requires relief when the township requires it. We are going under the assumption that it does, which is why we're here to talk with you all tonight. But we will need 20 feet of relief inside the 22-foot setback.
Okay, so that's off. I just want you to be specific.
Yes.
Where does that 22 feet, if you want to jump ahead, just show it. That way at least I'll understand it before we start hearing testimony.
So if you look at A5, it actually is showing a 30-foot front yard, but I believe, and Mr. Kachansky.
Can you put this up on the overhead?
Yeah.
That would be better.
Thank you.
So there is a setback line that is shown here, which is from your edge of your right-of-way, and it moves back 30 feet. I read the code that in this specific instance, the setback would be 22 feet because there is no parallel parking. Where there is parallel parking, the setback goes back to 30 feet, I believe, pursuant to the code. Kevin, do you agree with that interpretation?
I thought that the setback was to the front of the porch that was there from previous plans.
We're showing what would be kind of the code requirement setback, which would be either 22 feet or 30 feet. So the code gives two options. It's 22 feet or 30 feet based upon whether or not there is parallel parking located on the street at that setback point. I'll direct you to that section of the code here.
I'm not familiar enough with that portion of Conestoga Road, whether or not there is on-street parking or not, for that to trigger which requirement. I'd have to dig into that a little bit deeper.
In any event, the
So worst case is 30 feet.
worst case is 30, and we're showing that number there. If it were in fact 22 feet, the setback would simply move closer, as Mr. Kachansky just noted, it would move closer towards the front of the porch. In any event, the porch is within the setback today as an existing, and I think the setback is 22, but again, it's based upon the parking there. So we're showing 30 on the plan. That's where we're measuring
But
from.
the pergola that will sit 2 feet then off of the.
That's correct.
Okay.
So you'll see actually the right-of-way gobbles up that sidewalk that exists today. And you can see in one of the pictures that we have in Exhibit A4, you'll see that sidewalk. That sidewalk exists today inside your right-of-way. And it actually goes just beyond into almost right up against those bollards. And then beyond the bollards is another couple of feet, and that's where the pergola would be. It would actually be set back just a little bit into your patio area, but it's a 2-foot relief there.
Thank you.
Yep. It's a little confusing, and I apologize for that, just because of all the existing conditions.
The pergola is in front of what used to be the floral shop, yes?
Yes,
That's not the restaurant.
it is the restaurant now. There is restaurant in there. Luciano, I believe that's for private seating or parties?
Oh, it's not in use.
Not in use yet?
Not yet, no.
Okay,
But the plan is for it to be in use.
okay. It's being fixed for, it's being fit out for seating. And
It hasn't yet been approved and all.
no, so the outdoor permit for this site hasn't even yet been approved.
Well, this seems to be an off-premises outside dining.
It'll all be contingent on, and we're going to ask for this, it would all be contingent upon this restaurant. So Luciano does not want to obviously move forward with continued improvements to that building unless he can kind of piece it all together appropriately. So if this board were to grant this relief, we would expect it to be contingent upon, one, receiving the outdoor dining permit, which would then be tied to whether or not that space is properly used for a restaurant. Because under the code, you can't have outdoor dining without the existing on-property building being used as a restaurant. So it would all be contingent on that.
Will you repeat those for me? Contingent on outdoor dining permit?
That's the key. So
And
none of this can happen without that
you
outdoor.
said a second thing as well.
It's all tied together. So the outdoor dining permit is tied to the interior use of the space on that property. And then it's all tied to the number of seats that are allowed on that site. And then the appropriate reduction based upon the number of outdoor dining seats. But that's all run through Mr. Kachansky's office, the Office of Community Development. That's where you go for your outdoor dining permit.
So to clarify a few things, and I just, as I was checking on some of this stuff, an email confirmed by the Township engineer, that patio was put in without permits. Luciano is aware of that, and he's going to be going through the process to pull permits for that patio.
I was not aware.
Yeah, I just got confirmation.
Yeah.
Second, regarding the off-premise outdoor dining, there are provisions in the code that allow it on an adjoining parcel if it is either owned by or leased by the restaurant operator, but it has to be an adjoining parcel. So we had that in downtown Wayne, and it would also apply to this parcel. Since Luciano owns both, he would be allowed to take the outdoor dining on 912 for the restaurant on 910.
And Mr. Kachansky, I am correct, though. It's all tied to the permitting process through you all. You all confirm all of that compliance.
Correct. Yes, there's multiple approval processes, the design review board, which has gone through already, the zoning hearing board for this, and then an outdoor dining license, which has not been applied for, and which ultimately be the final review for this.
Right. That was my understanding as well. Yep. I don't know how helpful that was, but So if there are no questions for me, again, I'll just briefly call Luciano, who can just confirm some of the information I've given and maybe give a little bit of background as to the operation at the site and so forth.
Sir, if you'll raise your right hand, I'll swear you in. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
State your full name and spell it for me.
Luciano Di Felice, Luciano. Last name is D-I, space, capital F as in Frank, E-L-I-C-E.
Luciano, Spicy Bricks LLC is the owner of the subject property. Is that correct?
Yes, correct.
And what is your role with Spicy Bricks?
I'm the owner of Spicy
You're
Bricks.
sole member?
Correct, yes.
And who is the operator on the property for the restaurant?
Exit 13, which I'm also the owner of.
And you're the sole member of that entity as well?
Yes, sir.
And Exit 13 is a permitted and functioning restaurant in Garrett Hill, is that correct?
Yes,
And it is your intention to seek an outdoor dining permit for Mr. Kachansky in Radnor Township, is that correct?
yes,
And that permit has not been obtained yet, is that correct?
correct.
We've marked as Exhibit A5 some pictures, it is a rendering of your proposed improvement at the property as well as a general site plan. Is that correct?
Yes,
And your intention is to seek approval from this board contingent upon your receipt of an outdoor dining permit to install a prefabricated pergola structure. Is that correct?
that's correct.
And the pergola would be 13 and a half feet deep, meaning off of Conestoga Road, approximately 34 and 3/4 feet wide, running with Conestoga Road, and about 8 feet high. Is that correct?
Yes.
Do you know the material for the pergola?
It would be aluminum?
And the pergola will be located in the front yard. Is that correct?
Correct.
It will be located on the existing patio that is there today.
Yes, that's my understanding.
And if you turn to Exhibit A4 in your packet, any one of those photos will show an existing paved patio. Is that correct?
Correct.
And we've just recently heard from Mr. Kachansky that you'll be going through a process with respect to permitting for this patio.
Correct.
Was it your understanding that this was constructed without a permit?
I just found that out today.
And we do have on Exhibit A5, which is a plan prepared, an existing conditions plan, and on that plan, it shows the existing impervious coverage as approximately 69%. Is that correct?
Correct.
Well, you would not know, but the permitted impervious coverage in this district is 95%. So with respect to the installation of the pergola, are you intending to pave any additional areas of the property?
No.
You heard me offer some explanation earlier, but if you would confirm that the pergola itself would be located, essentially, we're looking for relief of about 20 feet, provided that the setback is 22 feet. Is that correct?
Correct.
So 2 feet into the setback would be where you would place your pergola.
Correct.
And it's your intention to obviously comply with the township code, but you would attach it to the ground per the township and their engineer's requirements. Is that correct?
Yes.
And turning back to Exhibit A5, is that an accurate depiction of the proposed pergola that you intend to install?
Yep. Yes.
And it's open air, is that correct?
Correct.
You're not intending to install any fences or other visual barriers there, is that correct?
Correct.
And how long have you been in the restaurant business, Luciano?
Yeah, since 10 years old, 40-some years.
And have any of the restaurants that you've been associated with incorporated outdoor dining into their business?
Yes.
And where you have outdoor dining, is it your experience that having that outdoor dining covered and enclosed in some way is beneficial to its overall success?
Absolutely.
And that is, that belief is reflected in the language of the code as well?
It is.
And is it your intention and belief that the pergola that you are seeking to construct or install here is is consistent with the intent of the outdoor dining code in Radnor Township?
It is.
You heard me speak a little bit earlier. You own this property and the adjoining property, is that correct?
Correct.
And you also own the property to the rear, is that correct?
Correct.
And the property to the rear of this is a separate zoning district in the township.
I believe so, yeah.
It's a residential zone.
Correct.
With your understanding of the code and my description, and you could not install outdoor dining in the side yard or the rear yard when it abuts the residential district, is that correct?
Correct, yeah.
So it was your only option in this location would be to install the outdoor dining in the front yard?
Yeah, that's, me and my architect have met about this, and it was the only option that we could, if any space, that's the only space we can go.
And you intend to keep the existing pedestrian sidewalk located both in front of the restaurants as well as the sidewalk along Conestoga Road, is that correct?
Correct.
The variance you're seeking tonight, is it the minimum necessary for the proposed use that you're seeking?
Yes.
Is it your opinion that, will there be any additional access points constructed as a result of this pergola?
No.
Are you intending to divert any additional traffic onto or off of Conestoga Road as a result of the installation of the pergola?
No.
And it's your belief that the installation of the pergola will not have any detrimental impact on receiving public services or on the provision of those public services to the restaurant or to the surrounding community?
None whatsoever.
And given that the pergola, given that outdoor dining is not what we're discussing tonight, but do you believe that the placement of the pergola and the use of the outdoor dining will alter the essential character of the community along Garrett Hill, or in Garrett Hill?
No, if anything, enhance it.
And finally, given your experience in the restaurant business, is it your belief that the relief we're requesting tonight would be kind of an essential component of a successful outdoor dining facility?
Yeah, it's very essential.
I have no additional questions for Luciano.
I have a couple questions. The roof of the pergola, I understand what a pergola is, but is it louvers that will be able to open and close, or will this be fine weather dining only?
Exactly, yeah, it'll be louvers, manual louvers, up and down.
And I guess my question then is for Kevin, does the fact that the roof can close impact the description of this as a pergola or change what we're looking at?
No, these things are called a variety of different trade names. I think it speaks, the images speak for what it is. It's no additional impervious surface. It's not a building. The patio underneath already counts for the impervious. That'll be addressed through the grading permit process.
Okay, thank you. Do you have any intention, well, will this only then be, let me try it this way. Will you be serving outdoor service during the winter?
So it's actually not prohibited, or not permitted in Garrett Hill. It's is it May to November, Kevin?
I think it's March through November.
March through November. It's specifically in the Garrett Hill district, it's restricted.
Seasonal.
Yeah.
Perfect, okay. Okay, and I just want to have you look at A3, which is the aerial photograph. If you could put that on the
Yep.
table. So I realize this is off of Google. There's no date stamp on it, and this might be a question for you, David, but I see what appears to be a grass area where you now have installed the patio. Is that correct?
That is correct.
Yes.
Okay, so then are the calculations on A5 for impervious, they were calculated when it was still grass, or they've been calculated since the patio was installed?
So the date of the plan for the pergola is January 25th, 2025. So it's my understanding these calculations are after the paved surface. We'll obviously confirm that as part of the grading permit process. In any event, we are certain to be below the 95% permitted.
Okay, thank you.
Dave, I have a question. What is the origin of the bollards? Why are they there, and how did they come to be there, and why are they illuminated?
It was more of a safety standard just to have in place for awareness, and it was part of the outdoor package plan that I had in mind.
So in the ordinance, Mr. Lord, there is a provision for pedestrian barriers around your outdoor dining surface to separate from pedestrian travel. It's any number of things, but it's to create what the code calls an enclosure around your pedestrian area. That's subsection 3 in 281.15.4a.
This was sort of a jumping of the gun.
What does that mean?
Maybe they went in.
This was put in anticipation of making an outdoor dining area prior to any relief being sought or zoning.
It is my understanding that there was an outdoor dining permit issued for this restaurant last year. Is that correct or not correct?
I don't recall that. Well, it wouldn't have been at this location because I don't recall, I don't know when that patio went in. And I thought that there was some space along the front of exit 13 on that sidewalk that provides access to exit 13. There may have been a table or two there or in the parking spaces, but I don't know. It wouldn't have been issued for this.
Right. So my response there is not that for this space, but I think the intent was to continue this year outdoor dining. But I don't disagree, Mr. Nagel, that this was a jumping of the gun.
Could the existing porch be used for outdoor dining that's surrounding the front of the building?
I don't know the answer to that.
It could be. It's limited. It's a smaller space, but absolutely, yeah, it definitely could.
Thank you.
That would also be within the front yard as well.
Going back to the bollards again, their installation, does that influence or impact relief that you're seeking? In other words, if they weren't there, the bollards weren't there, would you still need the same relief?
Yes.
And when, if and when the structure, the pergola is installed, if I look at the drawings correctly, the bollards would be outside. Is that correct?
That's correct.
They would be outside, and it looks like there's going to be maybe patio installed, or tiling, or whatever you want to call it.
So there's existing, if you look, Mr. Lord, to Exhibit A4, the patio itself is there, per Mr. Kachansky, was done without the permit. The pergola itself would be constructed on that patio. The plantings that you see in the pictures would be in the dirt area between the bollards, and the pergola itself would be located within the bollard enclosure.
And do I understand that the pergola is, the way it's attached to the ground with the referring to the image that's on the plan, which is, how will they be, is it a permanent attachment or semi-permanent? What is it exactly? Is it seasonal? You said it was seasonal, so can it be taken down?
It would not be intended to be taken down, but it would be a semi-permanent installation, because that's what is required by the code, that it be attached to the ground so that it's not affected by wind or weather. Mm-hmm. So I would define that as you have, as a semi-permanent, but it would not require footings and digging into the surface. You wouldn't penetrate anything other than to attach it.
What is that supposed to be? Is that going to be on the? I'm pointing to what looks like a solar panel. Is that going to be on the pergola? Or is that?
Oh no, that's the other building.
That's the other
It's
building.
Building on the other side. Okay,
the existing restaurant.
okay, thanks.
I have one more question. The proposal is for 13 and a half feet, I'm going to say deep, right?
13 and a half feet deep, yes.
What consideration was given at 13 and a half feet? You were going to put it 2 feet off the property line. What consideration was given to making it 3 feet, 4 feet, 5 feet off the property line, and thereby decreasing the width or the depth?
So I think a couple of things, and then I'll let Luciano go. And I know in my initial conversations, so they have the existing patio in place, and it's utilization of that patio, which was constructed with the intent of using it for outdoor dining. Placing tables, to your point, I guess we could push the pergola back and have some outside of the pergola area, or?
Yeah, I wasn't necessarily proposing that or suggesting that, but pushing it back so that your relief is less than potentially 28 feet.
Could be 28 feet, yes. You want to answer?
I was just going to add, going back a year ago when we were initially discussing the patio, I don't want to get off track here, but it was under my impression and our contractors that we could build a patio under 500 square feet without a grading permit, and hence we built the patio for 495 square feet. So we're just thinking, okay, how do we maximize the usage of the patio with the pergola?
Luciano, how many tables could you put under a 490-foot pergola?
6 4 tops.
Just curious, since this is going to be, proposed to be a budding Conestoga Road, just given it's a main artery, I'm thinking of traffic and safety for those who would be dining outside there. Just curious of what precautions you're contemplating.
So that was one of the things the architect did contemplate by moving it back as far as they did from the existing sidewalks. There's an additional, what is it, did we say, 8 feet from that sidewalk. It's pushed back. Also, while the ordinance contemplates maybe using fences around it, we thought here, for safety purposes, it was best to leave it open air. And that's where the pergola concept came in, because it's, again, the visual impediment would be people before it would be the pergola when looking left and right out of that parking lot. So safety was taken into consideration.
And the traffic.
Looking at the photograph that's on, I guess it's 4.
I think there's 3 there, Mr.
Or,
Lord. Is that right?
It's the photographs that show the bollards, and it shows the cement patio, we'll call it. Did I hear that correctly, that the cement patio was put in without a permit?
That's what we were told. Luciano received a note today, and he reached out to his contractor that was engaging. So we will take Mr. Kachansky at his word that there was no permit for that, but that was news to us as of this evening.
So assuming there had been a permit, would it be, without getting zoning relief, would it be conforming?
I know that it wouldn't exceed impervious coverage. I don't know whether that you can place a patio in the front yard. It seems, again, per the code, that you can. If you read it, you can put outdoor dining in the front yard. You have to put it on a paved surface. So it seems to me, reading the code, that it's a permitted installation?
I'm not aware of a zoning issue with the patio. It was the pergolas, the structure attached to that. We don't, from a zoning standpoint, other than impervious coverage, regulate patios in terms of setbacks. It would be the built structure on top of that that gets regulated.
Okay. That answers my
And that's the
question
pergola,
I was going to
Kevin?
ask. Okay, I got it.
That's the pergola we're talking, that's why we're here.
Correct.
Yeah.
Right. Any other questions of the board? Any further testimony?
We have none. I would ask that the exhibits be moved into the record.
Without objection.
Thank you. I know there are folks here to opine on this, so we'll step aside for a minute. I'll leave our exhibit packet up here if anybody wants to reference it.
Okay, very good. Okay, public comment. This looks like a veteran. So you know the routine, right?
I hope so. Good evening, Roberta Winters. I do. Do you need me to spell my name? ROBERTAWINTERS. And I live at 326 Williams Road, which is sort of a half a block away. The reason I am concerned about the structure is because I walk a lot, and the sidewalks are very close to this whole construction. I have had difficulty using the sidewalks in recent days, and when I went to Mr. Felice and asked him why there were some barriers across the sidewalks, he told me that the right-of-way was on the other side of the street. Those barriers, when I went back today, have been removed and are now not perpendicular to the sidewalk, but parallel to it. But I am concerned very much about walking through that area because it's very trafficked, and the sidewalks are very limiting sometimes. So I would like someone, before you approve this, to draw where the sidewalks go around that property and how they're impacted, because it's very close in there, and some of the ways you have to go are very challenging. That's the best way to describe it. I would also like to comment on the balustrades, those posts that are up with the lights. And as you can see, I am vertically challenged. And I also drive a Mini. And so when I drive down that road at night, there have LED lights that come out perpendicular to the road and do impact my vision. So I don't know if there's anything they can do about that, because it's probably just a personal handicap that I have. But I want to mention to you that those balustrades are probably this high, and there are lights. They look like they have been night concealed because there's a dome over them, but the light does protrude into the roadway. The other thing I would like to mention is it is not unlikely that when they have deliveries of produce, foods, and so forth, there are large trucks that come in front of that property, and sometimes they do pull over onto the sidewalk as well, because it is, Conestoga Road is not designed like, say, Lancaster Avenue or North and South Wayne Avenue. The other thing I am concerned about as well is that there were, in fact, 2 picnic tables on that grassy area before the patio was installed, and I believe it was after January of this year, but I can't testify to that swear to that. So I'll just say I believe it may have been. The other thing I would like to notice, I think there were also tables on that porch before that I believe I had seen. Finally, I would say that I believe there was some question about traffic, and would there be more traffic and cars pulling into that facility, given that there would be an increase perhaps of, they said 24 people, that would be 6 4-seat tables, and that might mean there would be more cars coming in and out of that property as well, and that is a very limited parking area. I'm sure you've heard the Garrett Hill issues of the parking before I came here tonight. So I'm concerned about the parking, the congestion, the balustrades, but most particularly the sidewalks, because it is a walking community, and the kids have to walk by there when they go to the park. They have a bus stop that's, that they have to proceed across through those areas. So I'm concerned about that, predominantly as the walking safety, as well as the additional traffic. Thank you.
A couple of responses from Ms. Winters, and I do appreciate the questions and concerns. First, with respect to the sidewalks, there are 2 sidewalks here. They will remain, and they will remain open. The one is actually within, again, I said, within the right-of-way, so that's kind of an issue that Luciano can't really touch. And then behind behind the patio, there's another sidewalk that actually connects through and runs in front of the restaurants that go further down Garrett Hill. So as you move, I think it's Slip and Bailey's, I think there's a pizza shop there. So that sidewalk traverses through that area, and then there's the one that exists out along Conestoga Road. And then I guess the last concern, which is the number of seats, and I think that's a good thing to raise. I don't know if I brought it up earlier, but the code does require as part of your permit that for every seat you put outside, you have to take away one on the inside. So I think that does help to regulate additional traffic. That's correct, right, Kevin? Yeah. So hopefully that will allay some of those concerns.
How about the lights that are on the bollards? Are they have to conform to township building code regarding what type of lights they are, how they're directed, whether they're directed down or out or capped or?
They do, Mr. Lord, and I think that'll probably all be part of that review process with Mr. Kachansky's team as to the patio and the lights. And if there's any concerns there or non-compliance, they'd have to be fixed.
I became aware of the lighted bollards when I met with Ms. Winters earlier today on a few things. So I'm going to go back and look at the design review board to see what was represented there to make sure that it's consistent.
Yep.
We're also addressing and going to review the sidewalk obstructions internally and make sure that we're all on the same page as to what sidewalks are required to be open and when and where and how.
So the sidewalk that you can see on the plan, that's between where the proposed pergola will be located and the porch area, I guess that's a porch area, existing?
Yes.
That's a sidewalk. It says existing concrete sidewalk, so that continues on down in front of other stores, the ones that you can see in some of the photographs. Is that right?
That's correct. That's what I had just mentioned. It runs down, there's a pizza shop, and then I think it's Flip and Bailey's all the way out to the corner.
Right here. And this would be a public sidewalk. It would remain available to walkers to use?
Yep, both sidewalks are open.
Okay. And the sidewalk that's here, I'm pointing to...
Along Conestoga, I see on your plan.
Along Conestoga, does that, see the parked car there, does that turn and connect with this other sidewalk, or does it just end there? It looks like it just ends at that point.
I believe that sidewalk ends, Mr. Lord, at that parking area. So you would have to make a left in front of that car and come back to the other sidewalk that then exists in front of exit 13 and then down the way there. There is no continuation of that Conestoga sidewalk further down towards the restaurants.
Okay. Any other public comment?
I'm curious, one
Mr. Nagel?
thing. Does this structure get removed in the off-season?
That question was asked earlier.
I asked
We do not intend to remove the structure, the pergola.
This would not have to, but any of the furniture underneath would, tables and chairs and if they have heaters or something like that would have to be removed. But the structure itself, we would consider as a permanent structure and make sure it's designed in accordance with the building codes accordingly.
Thank you.
Any further public comment? Sorry, any further public comment? Okay, seeing none, any board discussion?
I mean, I'm really just considering safety here, having people dining that close to the street. Just from, one is the sight lines from cars pulling in and out, but also just having people dine that close to a main artery kind of is somewhat concerning to me. And these bollards are not to prevent cars. This is just mere lighting. These are bollards that you could hit with a lawnmower and they would potentially be knocked over.
Well, that's why I raised the issue regarding how the lights might be masked or directed. How the lights would be directed, because they do seem to be in the photographs. Now, they're just photographs, so, but they do seem to be rather bright, which serves one purpose, but then people driving down this highway could be distracted, and the lights will have to conform to township code. I mean, that's the bottom line, and there may have to be changes to these lights to conform to the code.
I guess my only comment would be, it seems that for the community, a blank open patio is a bit of an eyesore, and to have that not be utilized seems like an awful waste for a community that wants to, offer its culinary delights to the community.
Any further comments?
Yeah, I'll just add that it seems like a lot of, different issues were potentially raised. They all kind of have to do with permitting that would be addressed later. So it sounds like if this is, approved conditional on those permits, I don't know how many of the actual issues discussed had to do with the pergola itself.
Let's,
Yeah.
go ahead.
Yeah, I guess what I would say is the request is for a dimensional variance, which is a lower standard than the use variance would require. Since we're commenting, I'm a little concerned about the 2 feet instead of something a little bit less, even though I understand, why that number was chosen. And actually now in looking at it, I hadn't thought about the concrete or the sidewalk closer to the building when I was asking that question. So I may have just talked myself out of my concern about that 2-foot setback. We're talking about a pergola with open sides. I hear the sightline concerns, but by the same token, if it's open, it's open. My recollection of the, I don't know what to call it, like it was a plant shop, right? That was there. They were all the way out to the sidewalk pretty much with product. So this may actually be into the street. So this may actually be an improvement in terms of visibility, not necessarily aesthetics. But we're not here for aesthetics. So.
Have a motion, please?
I'll make the motion that Appeal 3207 be granted. A variance from Section 280-49.8, Parent A, Parent 1, Parent 4 of the code to allow for the construction of this pergola over the paved patio, and the issue being the setback, consistent with the testimony and the information provided to this board.
Okay, I'll second that motion. Any discussion? Let me call the vote.
I'm not in favor.
Aye.
I'm in favor, aye.
I'm not in favor.
I'm in favor.
Okay, if my math is correct, that's 3-2, so it's approved. Thank you.
Thank you all. It's good to see you all. It's been a while, so glad to see you're all well.
Okay, we're going to take a break for 5 minutes. So we'll be back at, okay, we'll be back around 4, what is it? We got 5 minutes. 4:40. Trying to move things along.
John, how about that? She opened the door for me.
I know, you jumped right into it. I was,
Right in.
yeah.
Didn't take me much.
Yeah, she chickened out as soon as you went after her. Yeah.
Those two needs to be.
They needed some common sense. I mean, it's, yeah. Why why would they not bring the architect?
I guess they didn't want to spend the money, but you know what, good for them, because they could have been a waste.
Either for them or for
I'm pretty sure I
Let's see, who do we got here?
Yeah, right.
You know there's water over here, right, filtered?
You hired a flood attorney, probably should hire an attorney.
Who, that first company? I just said that they needed a lawyer. And they could really, I think building permits are a big appeal. They still have things they can do to yeah, I'm not gonna say what, yeah, although they were pretty.
So the roof was replaced by So I had to, so my son is
An opportunity to be heard.
so
Because the worst thing is they're going home tonight.
2 years into it, this was 40 years.
And we did it to them last time too, so you gotta try it. But you'll,
So I got $9,000 to replace.
oh, you have, oh, yeah. Right. Everybody wants to be your day.
Which was, one month
You have to give us.
well, it was a lot of money, and
I didn't
no,
the trees.
didn't have knee walls.
When do you start studying?
I've only got one. I forgot, I had a great schedule. I'll make sure I'm already done.
Just tell him to come down and talk to me. It's just prune back the sides that extend over the house. I know it's Radnor houses. I'm sure it's like. But, and I intend to stay in this house. They take me out.
You know what we did? I'm serious. That's why I was trying to.
You are just.
Yes, yes, so he'll be tonight, and he can present that. Exactly. I figured you got enough paper flying at you. I figured, what's the point? Nick's here. I'm sorry. That's why I have Yes. How are you? How are you? Because nobody but where would be oh, absolutely. And they work so
When they come in from.
So your large did we go over those references? I know. So take a look. The rest is there's a
He's sort of
I'd be curious when you check that line.
No, we're the next one up.
No more paper. Sorry.
I only put like numbers on
You
things.
saw how much we have to throw away.
No retaining wall here.
Steep slopes, are there steep slopes in there?
Trees.
All right. Yeah, we need one for the file, right?
Yeah.
You already have it and just literally put numbers.
Yeah, we can do it right at that time.
I wanted to address it.
These are the.
No, I was impressed.
Oh. Oh, okay, I put one, I put one in here, I think, already, so we already have. Villanova's abstaining, he's withdrawing. Villanova's, he's withdrawing.
They're, oh, withdrawing. We're continuing.
Continue it to a later date.
That's for that. Okay.
Villanova. I mean, Nick's going to be here, I think, to tell us that.
Hey, thankfully
already have it, Exhibit C?
Yeah.
Relief granted.
Okay, we ready? Everybody back?
Yep.
Okay. There's too much paper up here. Here we go. Okay, the next item on the agenda is appeal number 3208, the applicant, Radnor Hotel Associates, property located at 579 East Lancaster Avenue and zoned planned business. Applicants request a variance from section 280-123B of the code related to sign area, sign height, and number of signs on a building in the planned business district. In the alternative, applicant requests such other relief consistent with the exhibits and testimony.
Thank you.
Will you both testify or just you?
Just me.
Okay. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your full name, please.
Joseph, Joseph, Birch, Burch. Good evening. Thank you for your time tonight. I work at SW Bages Limited as the CFO. I'm also the shareholder in Harmon Corp., who is the general partner of Radnor Hotel Associates, who's the owner of the property. In the packet that I submitted, you have a copy of the deed marked as Exhibit A. Matt Egan's here with me, kind of just point out some things on the exhibits. Exhibit B here is a site plan of the property. The property is a 7-acre parcel located in the planned business district with frontage along Lancaster Avenue and along Radnor Chester Road to the east. The hotel was originally called the Treadway Inn and built in the early 1960s. A bank pad was added shortly thereafter, kind of towards the back of the property. And in 2004, we added what we call the 595 building to the property, where we have ground floor retail spaces and offices on the second and third floors of the building. There's also access roads that go around the property that feed to Radnor Financial Center, both to the west side and the north side. So we're pretty much wrapped around the back by the Radnor Financial Center and some retail spaces that they created. At this point in time, our property is going through a major renovation, bringing in a new restaurant, banquet and event center, and renovating the outside gardens, all of which will be named Triple Crown to be run by Fearless Restaurants, who also has many other restaurants in the township, including Autograph, White Dog, and Rosalie. We've also made some various renovations to the hotel, including a new facade, and I've included some pictures, and that's what I gave you, that I marked Exhibit C. I took these pictures myself. The first one that I marked C1 is a close-up of the entrance of the hotel and a section of the new facade. And you can see where what we're proposing is a sign there that I marked out in the red area. Picture C2, taken from the center of Lancaster Avenue, shows the same new facade in the distance and where that sign is going to be proposed. And C3 is kind of southwest of the property, and this is from the intersection going to either at the light where the main entrance to the St. David Square is. As you can see from the two pictures from Lancaster Avenue, the property sits down in a depression. From this southwest intersection, the hotel entrance is actually about a little more than 20 feet lower than that intersection, so you don't see the front door. Our hardship is the topography of the property in relation to the Lancaster Avenue. In addition, the entrance there that you can't see is about 180 feet off of Lancaster Avenue. It's pretty clear we're not in downtown Wayne here, where most of those storefronts are just 5 to 8 feet from the curb and pretty close to the roadway, so a sign that is just 15 feet above grade is sufficient. That doesn't work for us in this location. In order to have any meaningful signage to identify the hotel, we need to locate the signage higher than 15 feet, which exceeds the code. I think not too long ago you had Giant in here who was looking to add beer and wine as identifying an entrance. And I think the board's reaction at that point was everyone already knows it's there. We don't have that luxury with a hotel. Many times the people coming to our property are transient in nature and have never been to this property before. The higher signage helps us to identify the hotel, but also gives a general sense as you're approaching the property of likely where the entrance is. So it's kind of also a wayfinding marker for people coming to the property. I think we've all had our own experiences when we go to different cities and we're looking for a hotel. We're looking for signage, especially from down the road. You might see it up high on top of a building, and that's what we're trying to accomplish here. And as I mentioned before, there are many different uses on the property besides the hotel. There's a restaurant, there's an event center, there's a bank office, a salon, a makeup place, and the urgent care. So there's a lot of traffic coming here, so this is a good way for us to mark the property and help the hotel guests navigate the property. And finally, C4 here is kind of an aerial from Google. We're kind of in the center of this, and as you look around, we're surrounded by other PB district properties. Across from Lancaster is the St. David's shopping center. There's a Micro Center in there, Giant, and HomeSense. There's another office building across the street. And as I mentioned before, Lincoln Financial is behind us. So overall, I don't think what we're asking for the sign will really adversely impact anybody. Now for the actual sign. Exhibit D is a rendering of the proposed sign and the location. And what we're asking for is just where it says the Radnor Hotel. There'll be, the height of the letters will be 16 inches. There'll be individual channel letters about 5 inches in depth. During the day, the faces will show black, but at night it will be internally illuminated and the face will shine as white. The top of the sign is about 32 feet 6 inches above grade, which is higher than the 15 feet per code, and why we're here for this request. The square footage of the sign is just 35 square feet. Retail uses are permitted up to 60 square feet, so we're below the size. It's just really the height that is the issue for us. And we wanted to have a sign in here in the past, but until we renovated the facade, there wasn't a good spot in the past, but now with this design, it works much better for us. This type of variance has been frequently occurring in the planned business district. Exhibit E contains 2 past variance requests that were granted of a similar nature. The first submitted case is Appeal 3021. This was done by HomeSense and Old Navy. Both of these signs are higher than 15 feet, and HomeSense is actually larger than 60 square feet. But obviously, the board thought this was a good design and use of the signage, and it was granted because they exist. The second case is 3072, which is Lincoln Financial Group.
They had a request to put their signage at the top of the financial center buildings. Lincoln's sign is actually 39 feet, 7 feet off of grade. And just, I mentioned before, ours is less than that at 32 feet 6. They do exceed the 60 square feet. But again, they're in the plan business, and it's similar to what I believe we're requesting here. And I think that the fact that these have been approved and are up, obviously it's not a detriment to the residents because it's mostly all businesses in that area. Finally, Exhibit F, we did go to the Design Review Board and we presented this sign, and it was approved conditionally upon coming to the Zoning Hearing Board. And I would think the fact that they approved it, they see it as in keeping with the other signage that is in this area and acceptable. So with what I presented, I respectfully request granting of the variance to allow the proposed sign at the height of the 32 feet 6 inches. And I request that our application and the discussed exhibits be submitted into the record as part of this request, and I can answer any questions.
So your, the Exhibit C that you handed up, you have an Exhibit C, but this one, we'll substitute this one because each photograph is individually marked?
Yes, please.
And so the exhibits are moved in and accepted without objection. I do have a question regarding the sign and the height of the lettering. Does it have to, the lettering of the restaurant, I notice, and right below it, or at least it appears to be below it, on C.
I think it's D.
D, yes. Appears to be smaller in a slightly different font, if that's the right word.
Yes, that sign has actually changed. The background is now black. This was a rendering done well before they finalized their restaurant signage. So, but all we're asking for is for the hotel signage.
Well, looking at C1 and C2, because that was going to be my next question, there's a structure that looks like there had been a sign or some construction going on, and it's all white.
Yes.
Is that now what appears to be the Triple Crown restaurant?
Correct.
Okay.
What is white there is actually now black. It's since been painted.
Okay.
But that's also a different operation. It's a different restaurant that's run independently, similar to how the Wayne Hotel is, with Rosalie being a separate operation.
So you're requesting 32.5 feet. Is that the top of the sign?
Correct.
Okay, I just want to clarify the application. So the application actually speaks to height and number of signs. Are you only here for height?
If you look at C1, there's a sign that says the Radnor Hotel that's over the porte cochere. I'm not quite sure what that would be counted as because you're only allowed one wall sign. So if that were to be counted as a wall sign, we would like to keep that. That was put up a couple of years ago, many years ago. And the main reason for it was there was nothing that called out that overhang, and people would hit that overhang all the time. So that's why we put a sign there. We were going to build up a parapet, but the thought was better for a fence that wouldn't then allow the buildup of snow. So that's more of a safety marker in calling it out. But if that was to be called in plan business, you're only allowed one wall sign. So the worry was if you count that as a wall sign, then I need a second one.
Okay. Kevin, can I ask you to chime in on that?
I'd actually have to go back and see how that was approved under. I don't want to speculate it be something now and, have the board go off of that without being educated as to how it was approved, so.
Yeah,
I think
that's fair.
it's a fair assessment to assume worst case in that it is a wall sign, in which case they would be requesting. I struggle that that is a wall sign, just from the, but I don't know how it was previously approved in my predecessors, how they
But I
looked at
guess,
things.
I guess then the answer would be to err on the side of caution and grant relief for the second
Yeah.
sign. Although my concern with that would be, is that if they are going to have to come back for the Triple Crown sign,
Triple Crown is a different entity, so that gets its own separate sign calculations. So what I would suggest then, if you're going to assume worst case, is that it would be in then reference to both of those specific signs, so it's not like they come in for this and then add another wall sign later and saying, well, that wasn't a wall sign, we get our second wall sign. So it's specific to the sign on the portico. If the board is inclined to grant relief, you tie the two together.
thank you.
Do you happen to know the difference in grade between Lancaster Avenue and where the entrance is at the portico?
At the intersection of where the light is, where I took that
Let me tell
picture.
you where I'm going is, the height, if you're driving down Lancaster Avenue, is actually lower
Correct.
because you go down into that parking lot.
Yes, it's about 21 feet from the intersection. When you turn at the light where
Yeah.
St. David's is, the entrance grade is about 21 feet lower than that intersection.
Okay, thank you.
Any more questions from the board? Public comment? Any public comment? Okay, I don't see any. Board? We've had board discussion. Guess we'll call
I
a
know
vote.
personally, having moved here, had multiple issues trying to find Radnor Hotel, so I can't imagine somebody who doesn't live here not dealing with that hardship. So I think that's a very fair point. I also think the comparison of the Acme signage or Giant or whatever it was being a known location for locals is a fair differentiation from the hotel, which is going to be more out-of-towners and maybe the occasional local weekend stay. But it seems like these are real issues that the hotel will face and does face, and driving on Lancaster, it is an issue finding the hotel, the ease of entrance and things like that. So I think this is a solution to multiple problems that they're facing.
Yeah, I think you're in a business district here that we're right directly across the street. There are signs that have been adjusted before the zoning hearing board as a result of other signs being up there. And I don't think it's not, there's always a concern that Radnor, for example, wants to keep signage from beaming down onto the Blue Route as you're coming down from the expressway or going north on it, either direction. But, I mean, this area is designated a business area, so it seems sensible. And this appears to be the least smallest variant we can give to actually achieve what the property owner wants to try and do. So I'm okay with it. Anyone care to make a motion?
Sure, I'll do it. I move that we approve the request for a variance from section 280-123B of the code relating to the sign height and the number of signs in the planned business zoning district in accordance with the plans and testimony presented. I would add to it that the approval of the second sign counts the portico sign, the existing portico sign, as one, as the first wall sign, and therefore the proposed wall sign be the second for which we're granting the variance.
I'll second that.
Richard, are you excluding the sign area from, did you
I
need to?
didn't understand they needed
Okay,
sign area.
so you don't, okay, I want to make it clear, 'cause it was- okay.
Yeah, thank you.
Okay.
So I'm in favor.
Aye.
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 Okay, so that passes. Thank you.
Thank you.
Wait a second. Rich, stick, this one is different. Yeah, yeah. Okay, the next item on the agenda is appeal number 3209. The applicant, David and Susan Harmelin, property located at 799 Woodley Road and zoned R1 residential. Applicant seeks relief from section 280-15C of the code to encroach into the front yard setback. Applicant also seeks relief from section 280-112H of the code to encroach into the steep slopes.
Hi, guys.
Who will be testifying?
All three of us.
Okay, then I'll swear you in. Just everyone raise their right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes.
And your names one at a time and spell it.
Susie Harmon, S-U-Z-I-E-H-A-R-M-E-L-I-N.
John Hertz, John-Hertz. So Mr. and Mrs. Harmelin would like to do a deck and patio project. Their lot is a little restrictive as far as that goes, but I will let them explain their project and their home and the use of their outdoor spaces. They can do a little better than I can.
Hi, thanks for still being here. Hopefully this is a quick one. We want to replace our existing patio, which is very small and in need of repair. We want to replace it with a deck that will go over the existing footprint of the patio. Just over here, which is currently just this small space there. And then the deck would wrap around the back of the house.
Please.
I'm sorry?
Would you point it to
This
it?
is the existing patio, just this little square right here.
Okay, and that's what you want to replace?
We want to replace that and then wrap it around the back of the house and connect it to this side yard of our house. The space where we would like to put the deck is largely unusable because of the slope. The back of the house is almost all slope. So what it does is it separates our side yard, which is pretty small. It's probably about 12 feet before you hit the slope, and we have a fence. So it separates this side yard, and we don't really use it at all because it's so disconnected. And it's also where the entrance is to our walkout basement, which we just had refinished. So we would like to have a connecting deck that buys us back this unusable space in our yard and connects everything together. The area that's in question that we would need a variance for is actually not the back, it's this side. So our front yard, it's considered a front yard because it's a corner lot. It's our side yard, really. And it goes out to Roberts Road, which is the main road. It's not, we have no neighbors on that side at all. And it would still, we're only looking to go in by about 3 feet, so we would still have more than 50 feet before we even hit a main road with no neighbors. So we're not seeking a variance in the back, which does abut to a neighbor. We're within where we need to be there. It's just the area going out to Roberts Road. And it's minimal. I think it's 3 feet.
Okay, so you have up on this, on the screen, this drawing, which is RKW Engineering Services, proposed deck and patio.
Okay.
Okay, so we'll, none of these exhibits, none of these documents that are here are marked. We're going to mark your zoning board application, which contains the deed, some photographs, and your handwritten statements of the relief that you're seeking. We'll mark that as Exhibit A. Okay. And the plan is Exhibit B. Okay, I'm sorry, go ahead.
That's it, really. I can walk you through the photos if you'd like, so you can see the slope. It's just those couple of feet leading out to the Roberts Road side that we'd like.
I have a question for you.
yeah.
I didn't hear what we marked the plan as for exhibit number.
B, I think.
Okay, so on exhibit B, I see where Roberts Road sits, and I see the 60-foot setback noted. What I don't see is an indication of the measurement into the setback that you're proposing. Or am I missing it?
While they're looking at it, I can briefly say, when I talked to my contractor originally, he drew me this little, like, 11-foot thing, and I said, can't we go out by a couple more feet so it becomes more of a usable, almost room size? And he said, no, you get out of your building envelope that way, and hence this whole conversation. So I know they have the real measurements somewhere, but it's something like 3 feet.
Well, while they're looking then, the elevation, Roberts Road sits below this property?
Yes. Yeah, so that's what these photos are here. So this photo here is a photo of our house. This is Roberts Road on the right, and that's our house up on the left.
There's 3 photos up there.
Sorry,
Which one are
this-
you talking about?
This one here. This is Roberts Road.
Are these marked as exhibits?
Not separately, no. They're all in the
Were they part of the application?
Yes.
Okay, so
Yes,
let's
this is-
call this one A1 that you're pointing to?
Showing the wall? Showing a wall?
Yeah, the wall, yep,
Yeah.
the wall.
Okay, so that's A1.
So here in A1, this is Roberts Road on the right. The house is sitting up there on the left. The deck is still well to the left of the trees. It's not even past the trees. Proposed, yes, proposed. So in this photo, this is from our house.
Okay, that's A2.
Thank you. This is from our house, the last of the usable yard before you hit the slope, looking at Roberts Road.
And is this in the area where you're proposing
Correct.
for the deck?
Yes, this is exactly where we would want it to go beyond this fence, essentially another 3 feet.
Can you go back to A1 for me? Will you show me as best you can where on that photograph the deck would be situated?
It's back in here, behind the trees.
Behind the trees.
Behind the trees, yeah.
Here's a closer photo at A3.
I'm sorry, I didn't hear you.
A closer photo of A3, if you want to call it.
S-
This is the usable side yard right
Sir,
here.
if you could use the mic, hand
Sorry,
mic.
this is the usable side yard right here. And it gives you a better kind of picture of, you know, the deck would just come a little bit outside of this picture, which would be, you know, sort of.
And that pole you're seeing there is our walkout to our basement.
The little pole right
Yeah, that's our basement entrance. And this is from the back of the house facing to the front yard.
And the deck would cover the entirety of this
No,
grassed area?
no, it's only in the back corner, actually, kind of where the photo is taken, and then there's a patio that
And
goes
is this
there.
the side of the house where the easement, I'm sorry, where the variance is needed?
Yes.
It is, yes.
Do we have that measurement?
Yeah, it scales to 8 feet.
Oh, is it 8 feet? Okay.
That would be where the corner of the patio comes out into the steep slope?
That is right.
8 feet into the setback.
8 feet, encroaching 8 feet into the 60-foot front setback.
Okay. And then for the steep slope, so that area is noted as 14 to 20, I think, correct?
Yes.
Do we need to give relief for 14 to 20? I thought only excess of 20, but I don't remember.
That is correct. There's also some exemptions in there, so I'm not sure that steep slope provisions apply. I'd have to do a deeper dive in that.
So let me ask this. Yeah, but I don't necessarily want to do that. I guess the question is, by the 8 feet encroachment into the 60-foot setback, does that implicate any steep slopes greater than 20%?
It does not, no. And what we're asking for is pier footings for a deck. We're not asking for a foundation, so to speak. And my guess is that there'll be 3 or 4 of these piers in that general area. And a 20-inch circumference footing runs about 2 square feet. So we'd probably be putting about 10 square feet of footings individually throughout that part of the steep slope.
It is only 20% or greater.
Yeah, so just, right, so the implication here is not within greater than 20%, correct?
Correct.
Would the construction of those footings disturb anything above 20 feet, though? In other words, getting equipment? I'm sorry, Norma, I've been doing it to you all night. It's my voice, I'm sorry. Constructing those footings, would they disturb anything over 20% slopes?
No, they would all be in the 14 to 20% range.
So the equipment coming in and out of there won't disturb that area?
Correct. And equipment would probably be an auger and a motor.
Right, that's what I mean.
We don't have to take a
Stir.
backhoe in there or anything like that.
Got it. Thank you. I thought maybe that's the reason for the request of relief, but it doesn't sound like you need it.
You're going to move your exhibits into evidence, correct?
Yes, please.
Okay, without objection. Any board questions for the applicant? Any public comment? Any board discussion? Sorry, too much stuff here. I would move that the application be granted for relief from section 280-15, open parens, capital C, close parens of the code to encroach into the front yard setback, and also to approve the application to seek relief from section 280-111, capital H in parens of the code, to encroach into the steep slopes.
112.
What did I say? 112H. Pardon me?
He said 111.
Okay, 112H of the code to encroach into the steep slopes.
Second. Consistent with all the,
Consistent with the exhibits and the testimony presented to the board this evening.
Second it.
I guess the only question I have, John, is it doesn't seem that the applicant needs the steep slope relief. And-
14 to 20.
Yeah, so I don't know that we actually need to grant that relief. So I'd be opposed to granting relief for the steep slope since the applicant doesn't require it.
Okay.
Modify your motion.
How would we, well then, to the extent that there are steep slopes, they don't need relief from section 280-112H, right? So I can restate it and just leave that part out. Okay. So once again, well, we haven't voted on the other one, but we're just going to modify it. We'll just modify the motion so that it does not include relief from section 280-112H of the code because testimony and a review of the plans indicate that there's no need to seek relief because the steep slopes are, what, less than 20%? Okay.
Second then.
And vote, we'll call the vote.
Aye, I'm in favor.
Aye.
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 Okay, so that passes. Thank you.
Thank you very much.
Thank you very much.
Mr. Chairman, the next application, I misstated that Mr. Canelio would be here for another application. He will not be. But he did submit a letter of continuance confirming that he's extending the board's deadlines. He's asking for a 30-day continuance, and he has paid the continuance fee to the township. And we advised him that he didn't have to be here tonight.
Did you say a 30-day continuance?
He did ask for a 30-day continuance, yes.
I'm sorry, is this on the record?
This is for the application 3210 by Villanova University.
Okay, I didn't.
I'm
what do you want
sorry.
me to put down? I didn't know you
Yeah,
wanted.
oh, no problem. You can't get rid of me tonight, Mama. Regarding application 3210, I was mistaken and thought Mr. Canelio was going to be here for another application, but we advised him that he does not have to appear tonight to request the continuance. He submitted that in writing prior to tonight, asking for a continuance of Villanova University's application number 3210. He extended all of the board's deadlines for hearing the case and deciding it, and also paid the continuance fee to the township.
Do we need to take any action by approving it, or is it just?
Just
automatic?
the chair can note that the continuance is granted.
Okay, so it's noted that, for the reasons stated by counsel, Villanova University on appeal number 3210, through its counsel, has moved for a 30-day extension. They've paid the required funds, and the board approves the extension. The next item on the agenda is appeal number 3211. The applicant, Chris McClave, it would be spelled capital MC, capital CLAVE, property located at 102 Morningside Circle and zoned R4 residential. The applicant seeks relief from section 208-30D, 1 in parentheses, of the code to construct an addition to the side yard setback, the side yard setback, I'm sorry.
sworn in first.
If you want to hold that.
Yep.
thought.
Yep. Should I finish handing these out first? I do. Chris McClave, that's CHRIS MC uppercase C LAVE.
Austin Avery, AUSTIN, last name again Avery, A, V as in Victor, ERY. Thank you.
So those emails I just gave you are basically stating that all the information in their original letters still stands. I'm sure you guys are ready to get home, so I'll try to keep this simple. My name is CJ McClave. I'm here representing the Averys who live at 102 Morningside Circle in Wayne.
Let me just interrupt you for a second. You have a power of attorney that I see was submitted today. Is that correct?
Correct.
And we have your original application. Did you mark any of these exhibits as exhibits?
No, I did not.
Okay, so we'll take the application.
We pre-marked them for them,
Oh, that's
and they
right.
agreed along.
Yes.
So the application, I can go through the list if you don't have it.
I thought I had the list, but maybe I don't. So the application, what did we put down for the?
A1.
A1.
Okay. And the,
Deed is A2. The original zoning,
that would be the deed, the recorded deed is A2, correct?
yes. A3 would be the zoning board hearing decision.
I'd like to call out that there may be a discrepancy in the number of that specific appeal number. I think it may be off by a digit based off the original letter.
3161, not 3162. A4 will be photographs. A5, site plan. A6, request for extension. And A7, letters of support from neighbors. Am I good to proceed?
Yes, go ahead.
Okay, thank you. I'm here representing the Averys tonight, who live at 102 Morningside Circle in Wayne. We are requesting a variance for the aggregate side yard setback to build a small mudroom and powder room addition. This exact variance was already approved by the board July 20th, 2023, but it expired before construction began. The Averys later requested an extension, but it was denied due to time elapsed. We are now returning with the same exact request. Nothing has changed, and we're asking for your support again. It expired originally because the original contractor and homeowner couldn't agree on a budget. Soon after, the homeowner lost his job, and the family was undergoing expensive IVF treatments. These personal and financial challenges delayed the project beyond the approval window. This is still needed. The Averys are ready to move forward, and they have an even greater need now. The IVF treatments did work, and Sarah is pregnant. And the home only has one bathroom. These are not baby boomers, so one bathroom does not cut it anymore. There is no other feasible way to add a second bathroom into the existing footprint. This addition provides a necessary bathroom and mudroom for their growing family. We are asking for relief of 7'3" from the required 30-foot aggregate side yard setback.
All other zoning requirements are fully met: lot size, frontage, height, coverage, rear and front setbacks. Impervious coverage remains well under the 40% limit. There is no impact to the neighborhood. The addition is very small. It's a single story. It will not negatively affect neighboring properties. The Averys have received multiple letters of approval, and one of those letters happens to be from a neighbor that was approved for the same variance, same kind of addition. The project is consistent with the character and scale of the neighborhood. And the Averys have lived in this area for a very long time. They're committed residents. They're just trying to create more space for their growing family. So we're just here asking for your support.
Am I able to add commentary?
Yes.
Thank you. Yeah, and just to expand on, CJ's, I guess, presentation, if there's, just to call out if there's any potential concerns about the original, justification for the lapse in the variance. I'm gainfully employed. We're an expectant family, and we're ready to proceed with the project. So I just wanted to make note of that. And then additionally, if you want to reference the neighbor who this board previously granted a variance to, that letter involves Mr. Brett Harvey, who you can find as part of the exhibit. That's all. Thank you.
In Exhibit A7.
Other than the passage of time, has anything changed between the time that the variance was granted originally and today?
Nothing has changed. Everything is exactly the same.
So you moved your exhibits into evidence, and they're accepted without reservation?
Yes.
Board discussion?
I think it would be foolish to question the wisdom of the prior board.
Okay. Got to be careful with that one.
It looks like I was chair
These
at
guys
the
are
time,
getting
too,
older.
so, yeah, thank you, I appreciate that.
Any public comment? You sure now? Okay, can I have a motion, please?
I'll move that we approve the application of the McClaves, who seek relief from Section 208-30D, Parent 1 of the code to construct an addition in the side yard setback. This is Appeal 3211, consistent with the exhibits and presentation.
Second.
Vote?
Aye, I'm in favor.
Aye.
Aye?
Aye.
Aye.
Okay, it's approved unanimously. Thank you.
Thank you.
Thank
Have a good night.
This is still early.
Oh, no problem. Good luck with it.
Yeah, get you guys home before bedtime. Get you up. Oh, yes. We're adjourned.